Hello and welcome to the Legacy IAS. Today I am going to discuss about GS Paper 2 Mains 2025 UPSC. So without any further introductions, directly I will come to the question paper itself. So in this GS Paper 2, as in any other GS paper, there were around 20 questions were there, and majority of the questions they were belong to basically Indian polity, and then few in governance and social justice, and few questions basically on international relations. So this is the questions were there already. You must have gone through the question paper. So directly I will come regarding the theme of those questions. Okay, if you check it, these are the questions. Now directly come to the theme. So if we need to map basically 2025 GS paper, okay, then first question was regarding corrupt practices, representative people's act, undue influence. So this was directly from this topic, salient features of the representation of people's act, transparency, accountability in governance, GS paper 2. उसके बाद वन मोर क्वेश्चन, सेकंड क्वेश्चन वाज एडमिनिस्ट्रेटिव ट्रिब्यूनल्स वर्सेस कोर्ट ट्रिब्यूनल रिफॉर्म 2021. दिस वाज रिगार्डिंग स्टैट्यूटरी, रेगुलेटरी एंड क्वासी जुडिशियल बॉडीज, डिस्प्यूट रिड्रेसल मैकेनिज्म एंड इंस्टीट्यूशंस. दिस वाज द थीम or topic of that particular GS paper 2 syllabus. Then President's power to pardon, India versus USA. So this was comparison of the Indian Constitution. Then next question was nature of Jammu and Kashmir Assembly after Reorganization Act. So this is regarding Parliament and State Legislature structure, power issue and federal structure challenge. Next question was regarding Attorney General of India, role, rights and limitations. This was about appointment of constitutional post or constitutional bodies. There we will going to cover Attorney General. Next was women's social capital and empowerment. So this was regarding social justice, that is welfare schemes for vulnerable sections, where women is one of the vulnerable sections, plus issue relating to gender equity and social justice. Because of that this question was asked. Next question if we go, that is e-governance projects. E-governance project tech-wise versus user centricity. This question was about governance, transparency, accountability and e-governance models, success and limitation. This was the topic in the syllabus. Next question is civil society organizations, anti-state or non-state. So this was belongs to this particular topic. Development process, NGOs, self-help group, associations, donors and charities. Then India Africa digital partnership. So this was about international relations में bilateral, regional and global groupings, agreements involving India and affecting India's interest. Next is winning globalization, that is sovereign nationalism. This was effect of policies and politics of developed countries on India's interest. Next question is about constitutional morality, balance between judicial independence and accountability. This was about Indian Constitution, significance, provision, basic structure, constitutional values. This particular topic I used to cover in intro class itself. In the first few classes itself you must have gone through the class. Next is one more, amending power of parliament, procedural and substantive limits. So this is about basically Indian Constitution amendment, basic structure doctrine. So basically basic structure doctrine has completed like for example 50 years. So based on that. Then evolutions of collegium systems, comparison with USA appointment. So this was about judicial structures, appointment plus comparison of the constitutional schemes with other countries. So this question was mixed with two different topics. Next is central state financial relations and fiscal federal reform. So this was about federal structure, devolutions of power and finance to the state and local bodies. Then environmental pressure groups, again about pressure groups and formal informal associations and then role. Next question is inequality in ownership pattern, paradoxy of poverty. So this was about issues relating to poverty and hunger, development and resource distribution. This was the topic. Next is decision making not close to executions, development model flow. This was about development process and governance model, role of institutions and execution. Next question was about national child protection wala hai, NCPCR and digital era challenge for children. This is about welfare schemes and it's for vulnerable sections, where children are one of the vulnerable sections. Next 19th question jo tha, that is energy security as kingpin of India's foreign policy. This was about India, its neighborhood relations, energy diplomacy, foreign policy and global groupings. And last question was about United Nations reform, East versus West confrontation. This was again important international institutions, agencies, fora, structures, mandate, global politics, and India's interest. So see, I have first categorized all the questions, okay, in comparison or vis-a-vis to the syllabus topics of the GS paper 2. So now whatever the questions UPSC has asked, they basically were asked from the GS paper syllabus itself, that is mains exam syllabus. And many of the questions, they are basically current affair oriented also. So in today's this discussion, I will not going to give just model answer. That is the reason it stick to entirely in this particular session. I am going to tell why such questions were asked on the first place. That means what was going on in examiner's mind. Because of that they have asked such questions. Because if you come to know about these things, why such questions were asked in the UPSC, then easily you can think about the next year what type of questions UPSC is going to ask, and you will understand the importance of current affair also, specifically for the mains exam. So without any further delay, I am just going to discuss one by one question. So for example, if we come to the first question, okay, so first question is about discuss the corrupt practices, okay, discuss the corrupt practices for the purpose of the Representation of People's Act 1951. So first part of the question is this: discuss the corrupt practices that is basically mentioned related to the Representation of People's Act 1951. Analyze whether increase in the asset of the legislator means MP and MLA, analyze whether increase in the asset of the legislator or their associates in the sense their family members, colleagues, because their income also going to be increased, disproportionate to their non-source of income, would constitute undue influence and consequently a corrupt practice. That is the question. So see, this was 10 marker question. So for the first 10 questions, there are 10 markers and we need to answer in 150 words. So question already you understood about that कि जो MLAs and MPs हैं, इनका जो income has been increased, like for example with 45 to 100% CAGR, इतने से उनका income बढ़ रहा है every year. So this is going to influence basically the elections also, and it is constitute a corrupt practice. So why this question was asked? That is one important thing that you have to ask. So why UPSC asked this question? First is Representation of People's Act 19. UPSC regularly test the salient features of Representative People's Act because it governs elections, candidates eligibility and corrupt practices. So UPSC keep asking such questions. And current affair context क्या? Frequent media reports of sharp rise in legislators' assets between two elections, basically ADR report, election commission disclosures, and one more thing. In September month and November month 2024 also, there was a news basically in The Hindu, Indian Express and various newspapers regarding Supreme Court directions on disproportionate asset cases against MPs and MLAs, especially in context of Tamil Nadu MPs and MLAs case. Example like Jan Chaukidar case, very old case, Lily Thomas case on disqualification, and one more case, Subrahmanyam Swamy versus Manmohan Singh. Here Supreme Court directions is regarding disproportionate asset. That is the basically context. Because of that such question was asked. अब आपको कैसे लिखना है? If we need to break down the question, okay, we need to break down the question is first discuss part 1. Part क्या है? Discuss the corrupt practices for the purpose of Represented People's Act. So here examiner wants you to recall section 1, 2, 3 of Representative People's Act 1951. If you read The Hindu or simply your class notes, this section 123 is very important section. You have to remember this section to note down in your exam also. List of major corrupt practices like bribery, undue influence, appeal on religion, promotion of enmity, publication of false statement, booth capturing. These things are mentioned that you have to answer. Second part of the question क्या था? Analyze whether increase in assets, that is disproportionate, would constitute undue influence and consequently corrupt practices. So here examiner test your analytical ability to understand. So asset rising disproportionately may not directly to be in section 123 but create undue influence because money power, muscle power that you are going to use in elections. सी यस एंगल में आप ले सकते हो यस यूज ऑफ इल गोटन वेल्थ डिस्टॉर्ट्स लेवल प्लेइंग फील्ड इंटिमिडेट्स वोटर्स अनड्यू इन्फ्लुएंस इन स्प्रेड नो एंगल में क्या ले सकते हो लीगली डिस्प्रोपोर्शनेट एसेट फॉल अंडर प्रिवेंशन ऑफ करप्शन एक्ट and IPC and that is Bharat the BNS also not explicitly under representative people's act. See undue whatever the disproportionate assets is there that need to be covered basically under prevention of corruption act not under representative people's act but it is still unethical. So that angle you have to write. So way forward मान भी सकते हो need electoral reform, asset disclosure, strict election commission monitoring. These things need to be there. So that was the question number 1. Now move to next question. Comment on the need of administrative tribunals as compared to the court system. See, we are having a administrative tribunals. Okay, you must have read that is one article, Article 323A and Article 323B. These were added by 42nd Amendment Act. Correct. So the question is, we have to compare these administrative tribunals with the court system. Court means that is judicial system, that means Supreme Court and High Court, and these are the tribunals. Example like CAT, okay, CAT, Civil Administrative Tribunals, and assess the impact of recent tribunal reform through rationalization of tribunal made in 2021. So this was the question basically, clear? Now we have to link with it. Link कहाँ से करना है? It is in statutory and regulatory body and quasi judicial bodies में you are going to cover this administrative tribunals. Now current affair क्या है? Hook कि Tribunal Reform Act 2021 it basically merged 9 tribunal. जो tribunal reform किया गया था 2021 में it had basically merged total 9 tribunals. Like GSTAT, FCAT, Airports Appellate, etc. These were abolished basically. Number of tribunals were there, and many of the tribunals they were sharing the same domain. So that rationalization has been done. So whether it is better or not, that we need to assess in this particular okay. So if you go further, Supreme Court struck down parts of the act also that was in the news. Vacancies and pendencies are there, like for example delay in NCLT, ITAT, debt recovery tribunals. So debate, do tribunals really reduce burden on courts or create parallel justice with weaker independence? That was the question. Now we need to actually break down this question. सबसे पहले part 1 जो इसका solve करना है, we need to answer this question. Need of administrative tribunals as compared to the court system. Why do we need basically these administrative tribunals when already we are having the court system? So first is why tribunals were set up. That is the main question is. So क्यों set up किया गया? Because we require specialization in technical domains. Because those judges who are basically in the benches in High Court and Supreme Court, they are not the expert basically in this technical domains. Because of that, we needed basically this tribunals. So tribunals we need because we require specialization in technical domains like tax, like telecom, like environment, like company law. This was the reason. Second important reason, faster है ये. Court जो system है that is slow and court is already overburdened. So this is basically faster, less formal procedure versus conventional court, and it reduces burden on High Court and Supreme Court. Clear? But shortcomings क्या है इसके? Shortcomings ये हैं. These tribunals often they are headed by retired bureaucrats. So that is the reason there is a conflict of interest, because यहाँ पे the cases related to the government and they are headed by the government type individuals only, like retired bureaucrats only. So executive is heading these particular tribunals. They are not judges. So doubt on the independence. Next is parallel appeals. Parallel appeal क्या है? कि earlier ऐसा था कि whenever tribunal is giving any judgment, then we can appeal against the judgment of the tribunal indirectly to the Supreme Court. So we were bypassing the High Court. But after L Chandra Kumar case, where Supreme Court says that judicial review is the basic feature of the constitution, and because of that you cannot bypass the High Court. So now whatever the decision taken by the tribunals, that appeal lie against those decisions in High Court also, and after High Court you will go to the Supreme Court. So ultimately we have lost the purpose. Purpose was to reduce the burden on Supreme Court and High Court, but because of that reason is ki now appeal is lying basically in High Court and Supreme Court both. So where we are going to reduce the burden, that is the shortcoming. The next part is what is the impact of this Tribunal Reform 2021? We need to assess the impact of Tribunal Reform 2021. So some positive, some negative. Positive क्या होगा? Rationalizations, because it removed redundant bodies, reduced fragmentations. Aim क्या हो गया? Quicker disposals, reduced cost and clarity in jurisdictions. But negative क्या हुआ? Reduce access to justice, because appeals shifted to high courts, increased workload. Supreme Court flagged excessive executive control over that. Many tribunals remain understaffed. That is the so ultimately what points you need to keep in mind? Administrative Tribunals Act 1985 through 42nd Amendment we already covered. L. Chandra Kumar versus Union of India case, where tribunals subject to judicial review of High Court and Supreme Court, already we have covered. Tribunal Reform Act 2021, that also we could have mentioned over there. And data you can give like 3.5 lakh cases pending in tribunals, 2024 reports, and 50% of the post that is vacant, that you can write in this particular question. I hope it is clear. See, जितना मैंने बताया, whatever I have told you, if you are able to answer 70% of that also, still you get good number. ऐसा नहीं कि whatever I told you, you have to mention everything. This is humanly not possible in the mains exam. See, only few candidates will be there who is able to write that much of content in answering any UPSC main question. So that is the reason you should not worry about that ki you are not able to write these points. You should not worry about it. If you are able to mention just 60 to 70% of these points, whatever I am mentioning over here, that is more than enough. You have done a wonderful job there in the mains exam. Now next question is, that is third question regarding this comparison of the Indian constitution with other world's constitution. So question is this: compare and contrast the president's power to pardon in India and in the USA. Are there any limits to it in both countries, and what are preemptive pardons? See, इसमें two parts हैं आपके. First आपको compare and contrast करना है, okay? Second is what are preemptive pardons? That is completely a very factual questions. कि what is the meaning of this term preemptive pardons? And question के अंदर 10 marker question 150 words में लिखना है. Why this question was asked? Okay, first we need to understand that part. Because in current affair में, if you knew, in the US there was a debate कि Trump's self-pardon possibility and preemptive pardons were widely they were covered. Like January 6 capital case 2024 elections वहाँ पे था. And if you notice, ex-US president, that is Joe Biden, he also used this power before leaving the office. So that is the reason this was in the news actually. And in India, recent use of president, governor pardon and remissions like Rajiv Gandhi assassination case, convicts remissions by Supreme Court, Bilkis Bano remission controversy, and because of that, that question was asked in the UPSC. Correct? Now, we need to break down that question. What was the first part? Compare and contrast India and USA. Directly. So India में already you know article number 72 for the president and article number 161 for the governor. So president can pardon, commute, remit, suspend, respite for the union law offence, court martial cases, death sentences. Governor has parallel power under article number 161. See, अगर आपने if you have done the class notes properly and read Lakshmikant also, this is very easy. That is completely halwa type of content. USA में क्या है, there is an article 2 section 2. Again, if you remember these things, you can mention in your answer. And if you are not able to remember, just leave it. That is not that important that I have to mention article 2 section 2 entire that much of detail. It is not required. Just write like president, because at that time it was in the current affair when Joe Biden had used this pardon power. At that time the Hindu has covered very beautifully and Indian Express also has covered. So वहाँ पे simple लिखा था, president has plenary power to grant pardon for federal offences. Understood? For federal offences, except in case of impeachment. Impeachment that cannot be used, but in federal offense में that can be used. It covers reprieve, commutation, amnesty, pre-trial pardon, that is same. Now contrast में देखते हैं क्या contrast ये है कि जो इंडिया की पावर है, जो इंडियन प्रेसिडेंट यूज, इंडिया पावर इज सब्जेक्ट टू जुडिशियल रिव्यू. I already covered this particular case in our class also, or even if you have read any notebook also, then you can cover this. Like Ibru Sudhakar case and Kehar Singh case, यहाँ पे बोला गया है कि whatever जो इंडियन प्रेसिडेंट ओके टेक डिसीजन दैट इज सब्जेक्ट टू जुडिशियल रिव्यू. बट इन केस ऑफ यूएसए में जो प्रेसिडेंट पार्डन पावर है इट इज इंडिपेंडेंट. ध्यान रखना, इट इज इंडिपेंडेंट एंड एब्सोल्यूट. दैट मीन्स इट इज नॉट रिव्यूएबल बाय द कोर्ट. So in case of India, if Indian president has taken any such decisions, then that decisions can be turned down also by the Supreme Court. But in case of USA, it is not possible. That is the difference between India and US. Are there any limit? So India may cannot pardon the state offense because that is done by the governor only, subject to judicial review. That is USA में they cannot override state convention. जो states हैं वहाँ के that cannot be done. Or impeachment, that is basically a limitations are there. Now next is what are preemptive pardon? That is the next part of the question. This is completely a factual question. So preemptive pardons means pardon issued before convictions or trial to immunize from prosecution. For example, if you have done an offense, now trial is still not started, you are not convicted yet, and before that itself we have to use pardon. Like India में क्या होता है कि first you have to utilize all the machinery from the local court to the Supreme Court, and then only you can use, for example, and then for example this is the case India में होता है यहाँ पे. So preemptive pardon means pardon issued before convictions also. Like famous case is Gerald Ford's pardon of Nixon in 1974. Again, if you are not able to remember these things, that is not an important part. Is if you are able to, because 150 words में आपको लिखना था, that is more than enough. 150 words आपके हो जाएंगे if you write intro, body and conclusion. Next question is question number 4. Again, it was in the current only. Because of that, this question was asked like discuss the nature of Jammu and Kashmir Legislative Assembly after Jammu and Kashmir Reorganization Act 2001. That means after 370 removal, what is the status of Jammu and Kashmir as a union assembly? So see, it will compare either from Delhi, or because Delhi is also UT and other is Puducherry, because these are the two this UTs are there with assembly. The third आपके पास UT आ गया with assembly Jammu and Kashmir. So we need to read some article like 239A and 239AA. करेक्ट है. अब दिल्ली के केस में क्या है कि वी ऑलरेडी नो इन केस ऑफ दिल्ली केस में वी ऑलरेडी अवेयर दैट कि दिस पब्लिक ऑर्डर, ओके, दैट इज लॉ, पब्लिक ऑर्डर एंड लैंड, दे आर नॉट अंडर दिल्ली गवर्नमेंट. सेम फॉर एग्जांपल जम्मू एंड कश्मीर ऑल्सो, public order and that police that will not be under the this, for example, under the control of the Jammu and Kashmir government. That we need to write. See why this question was asked in the UPSC. That is the first important question you have to ask to yourself, because Jammu and Kashmir Reorganization Act 2019 हुआ था, बहुत इसमें झगड़ा चला, and then case reached to the Supreme Court also, and delimitation commission हुआ 2022 में, and then Supreme Court verdict आया December 2023 में. In Supreme Court verdict में they have appealed 2019 decisions and directed that legislative assembly election be held by September 2024. So in 2024 में election was conducted and first assembly election in UT done. So that was the reason this question was asked. So आपको break down में करना है, तो आपको क्या intro में mention Reorganization Act 2019, Jammu Kashmir became UT with legislature, okay, altering the nature of assembly. This now question was asked, what is the nature of Jammu and Kashmir assembly after Reorganization Act 2019? So आप क्या करोगे? Earlier it was a full-fledged assembly under article number 370. Now it is a union territory with assembly like Delhi or Puducherry. Bicameral legislative council abolished, because earlier जो जम्मू कश्मीर था there were two houses like Vidhan Sabha and Vidhan Parishad, but now it has abolished. Now only a unicameral. Strength 90 elected MLAs are there as per 2022 delimitation. Earlier it was 83 से बढ़ा के they have done 90. Now power and functions, that was asked in this particular question. If you check what question was asking about the power and functions. If you take okay this key briefly describe the power and function of the assembly of the union territory of Jammu and Kashmir, that was the question. So what is the power and function? Key this can legislate on a state list, and concurrent list matters, except public order and police, which still remain with the center. This is just like article number 239AA. Money bills, budget, control over executive council of ministers headed by CM, they will take care of. LG retain a special power, especially regarding public order, police and services. That clearly has been mentioned under this Reorganization Act 2019. Now, subject to overriding authority of parliament. That was the answer. Ekdam easy hai. Next question is about Attorney General of India. So, Attorney General pe definitely this is not the first time that UPSC asks questions. The UPSC already asked questions earlier also. So, Attorney General of India play a crucial role in guiding the legal framework of the union government and ensuring sound governance through legal councils. Discuss his responsibilities. क्या discuss करना है कि what is the responsibility Attorney General is having, what is the right Attorney General is having, and what is the limitation in this regard. Three things we have to write over here. So simple है, क्यों पूछा गया? Because in 2023-23 R. Venkatramani was appointed as Attorney General of India after K.K. Venugopal's tenure. Several high-profile cases that is basically taken care by this Attorney General only. So question is क्या? First आपको intro लिखना है, 2-3 lines only because it is 150 words only. Like define Attorney General as the highest law officer of the Union under Article number 76. एकदम हलुआ type. Now part A में क्या है कि आपको बोला क्या what things we need to answer, responsibilities, limitations भी हमको and rights. So first responsibilities means what he does. So constitutional post under Article number 76. He is chief legal advisor to the government of India. Represents Union in Supreme Court and High Court everywhere, and defends Union in presidential reference Article number 143. This was in the news also recently when, for example, Supreme Court says that कि जो governor है governor whenever they basically reserve the bill within 3 months they need to take decisions basically. So वहाँ पे Article number 143 was in the news. So please read this about Article number 143 because in the next prelims exam question can be asked from here itself. So it defends Union in presidential reference, and this Attorney General also draft legal advice. Not policy, legal advice only on policy and legislation. This is the responsibility he is having. So ultimately he is the lawyer for the government of India. Simple, as simple as possible. Now rights क्या है उसके पास? Very important है कौन बनेगा करोड़पति type of questions. What is the rights he is having? Right of audience in all Indian courts. That means whatever the Indian courts are there, high courts and Supreme Courts. Only one Supreme Court right now we are having. So right of audience in all Indian courts he is having. He can participate in proceedings of parliament committees but with no voting power. This is very simple. In Lakshmikant directly it is mentioned. In class notes also if you have covered my class, this is very simple. Privilege of being heard in matters of concerning government. But what is the limitation? Limitation क्या है कि he is not a full-time government servant. So he may take private practices but he cannot take any practices that is against the government of India itself. So in criminal case also he need to take permission of the president. He is bound by the advice-seeking role. That means he lack independent prosecutional power, and his terms and conditions that are not fixed by the constitution, that is fixed by the president only government. That is the question. So I think this is completely straightforward question. इसमें आपको you should not use much of your mind. If you have revised properly, then this is a straight question. Directly एकदम आपको 10 marks एकदम free में दे दिए उन्होंने, ऐसा है. Next question is constitutional morality. This is my one of the favorite basically this key term, keyword in polity, and even I think in the first class itself I used to explain about what is constitutional morality is, because this is the favorite keyword for the Supreme Court also. The constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. In view of the above observation of Supreme Court, I told you Supreme Court used this term. Explain the concept of constitutional morality in its application to ensure balance between judicial independence and judicial accountability in India. That was the question. I hope this is not that difficult question. Now, why this question was asked? Because reason is this, judicial accountability debate. You have seen vice president, to earlier vice president the, he used to actually give lot of lectures about the judicial accountability. So judicial accountability debate during electoral bond case, Article 370 verdict, and same-sex marriage 2023, criticism of judicial overreach versus independence, that was in the news. Recent discussions on judicial conduct, transparency in collegium appointment, live streaming of proceedings, disclosure of asset of judges, Supreme Court's own reference to constitutional morality in landmark case like Navtej Johar case, decriminalizing homosexuality, Sabrimala case, and JC case. Supreme Court has used this term even in this misusing of the power by the governor. In such case also Supreme Court has used this term even in Delhi government versus Union Home Minister case. Here also Supreme Court has used this term constitutional morality. अगर आप गूगल पे जाओ, वहाँ पे आप सर्च करो कॉन्स्टिट्यूशनल मोरालिटी एंड न्यूज़ पे क्लिक मार दो, आपको इतने सारे आर्टिकल्स मिल जाएंगे रिगार्डिंग दिस कॉन्स्टिट्यूशनल मोरालिटी ओनली. सो फर्स्ट इंट्रो में क्या लिखना है, यू हैव टू डिफाइन व्हाट इज कॉन्स्टिट्यूशनल मोरालिटी. कॉन्स्टिट्यूशनल मोरालिटी होता क्या है कि मोरल वैल्यूज विच आर बेस्ड इन द कॉन्स्टिट्यूशन. सिंपल, कॉन्स्टिट्यूशनल मोरालिटी मीन्स दैट मोरल वैल्यूज विच बेसिकली एग्जिस्ट इन द कॉन्स्टिट्यूशन. सो कॉन्स्टिट्यूशन में व्हाट टाइप ऑफ मोरल वैल्यूज आर एग्जिस्टिंग बेसिकली. तो इन कॉन्स्टिट्यूशन में जो आपकी मोरल वैल्यूज हैं दे आर, for example, they will be around like justice, like rule of law, like liberty, these are the equality, these are the moral values are correct. So now, so you have to सबसे पहले define constitutional morality, that is a part A you have to define. So it term was popularized by Dr. Ambedkar in Constituent Assembly debate, refer to the, इसका मतलब क्या होता है, it means refer to the adherence to the spirit of the constitution, correct, not just literal text. That means what was the intention of the constitution, that matters, not the text of the constitution, that matters. It upholds values like liberty, equality, rule of law, fraternity and justice. It serves as ethical compass of four institutions as well as citizens. That was the definition. Part B में क्या बोला, part B is about the applied to the judiciary, then applied to the citizens. Applied to judiciary, that means independence versus accountability. So judicial independence definitely है because of basic structure doctrine. Judicial accountability, yes, judges are unelected, but they must remain transparent and responsible. So balanced by constitutional moralities like protects independence, judiciary must strike down unconstitutional acts fearlessly and ensure accountability also through adherence to the rule of law. Judiciary also need to adhere to rule of law, reasoned judgment देने चाहिए, judicial ethics होना चाहिए, public scrutiny होना चाहिए. These things must be there. That is what this question is. If we go to the next question, again these are the 250 words question, okay, 15 marker. Indian Constitution, if you read, has conferred the amending power on the ordinary legislative institutions like parliament, okay, because who can amend the constitution? Parliament only, with a few procedural hurdle. Procedural hurdle क्या होता है कि लोकसभा से पास करना है, राज्यसभा से पास करना है, both there is no joint sitting in case of amending of the constitution, correct है ना, and then what power president is having, special majority is required. These are the procedural hurdles. In view of this statement, examine procedural and substantive limitations on the amending power of the parliament to change the constitution. That means आपको ये बताना है कि whenever parliament wants to amend the constitution, then what type of procedural hurdles are there and what type of substantive limitations are there, that you have to tell. Okay, so यहाँ पे because it was in the news because of basic structure doctrine, uniform civil code, one nation one elections, article 370, because of that this was in the news. So first intro आपको लिखना है कि constitution allow amendment by parliament to ensure dynamisms because our constitution जो है that is a living document. But framers introduced procedural hurdles and judiciary basically added substantive limits to preserve constitutional identity. So procedural hurdles have been given by the constitutional makers themselves and judiciary has added substantive limits. So what is the procedural hurdles are there? It is very, very simple. Article 368 provides procedure to the parliament to amend the constitution. Like simple majority for some provisions, a special majority like 2/3 of present and voting plus majority of the total, that is absolute majority, and some of the case जहाँ पे special majority is required plus ratification of half of the state. That means जहाँ पे भी federal provisions of the constitutions are there, like elections of the president, like 7th schedule is there, in that case ratification of half of the state is required, for example in case of GST implementation. So these are the procedural hurdles that is already given by the constitution. लेकिन substantive जो limitations हैं they are put by the judiciary. तो यहाँ पे क्या करना है कि yes, express limitations like cannot amend provisions requiring ratifications without state. Judicially involved limits like case 1 on the Bharti case. So now even though procedure is there, they have followed the entire procedure, but there is a case 1 on the Bharti case is there जिसमें कि they cannot violate basic structure of the constitution. Same when you have covered article number 21. Article number 21 क्या बोल रहा है कि that procedure established by law is interpreted as due process of law. Here Supreme Court is going to check whether procedure has been followed or not, plus whether particular law they have passed, okay, whether something they have that is fair, reasonable and for example this justiciable hai ya nahi. And then Kesavananda Bharati case, because of this basic structure doctrine, Parliament cannot alter the basic structure like rule of law, like judicial review, like secularism, like federalism, separation of power. So this is basically a substantive limitation. So practical limitation kya hai? Practical limitations are like political consensus is required, judicial review is there, and public opinion is there. So these are the things you have to note down in your answer. I think this question was also not that difficult questions. Yes, if you have not revised properly, if you have not carefully read all those materials that is you are having in the class notes, then I think you may feel it is difficult, but when you read questions and just you actually divide the questions in various parts and understand the keywords that has been given in the question, then I think question was very, very easy. Now comes to the next question, question number 13. So question number 13, if you take, it talks about the discuss the evaluation of collegium system in India. Again, ekdam directly halua question. First judge case, second judge case, third judge case, Lakshmikant mein, class notes mein, everywhere you can read easily. Critically examine. क्या करना है? The advantages and disadvantages of the system of appointment of judges of Supreme Court of India and that of the USA. So comparison of the constitution is also there. So collegium system is most of the time it is the ongoing basically debates. Supreme Court live stream collegium resolutions, partial transparency in 2023, NJC struck down 2015 में, that is fourth just case we used to call. UPSC ने this question was asked in the UPSC prelims also, still it is relevant, and US Supreme Court adjoined this appointment. These are in the news only. So अभी क्या लिखना है आपको intro में कि judges appointment are key to judicial independence. India evolved collegiums through judicial rulings while unlike USA's political nomination model. So evaluation of collegium systems क्या है, कुछ नहीं पढ़ना है. आर्टिकल नंबर 124, आर्टिकल नंबर 217, फर्स्ट जज केस, सेकंड जज केस, थर्ड जज केस, देन एनजेसी 99th constitutional amendment. सिंपल. एडवांटेज क्या है collegium सिस्टम का? इंश्योर जुडिशल इंडिपेंडेंस फ्रॉम द एग्जीक्यूटिव, यस, सीनियोरिटी बेस्ड है, स्टेबिलिटी एंड कंटिन्यूटी भी है, एंड सब्जेक्टिविटी विल बी लेस देन, एंड शील्ड फ्रॉम पॉलिटिकल प्रेशर. डिसएडवांटेज क्या है? बिकॉज इट इज वेरी ओपेक, लेक ऑफ ट्रांसपेरेंसी, एलिजेंसेस ऑफ नेपोटिज्म एंड फेवरेटिज्म, जस्ट लाइक बॉलीवुड ओवर हियर आल्सो. डिले ड्यू टू द एग्जीक्यूशन जुडिशरी टसल्स. नाउ कंपैरिजन कर रहे हैं यूएसए के साथ. यूएसए में क्या होता है कि यूएसए में जो जजेस होते हैं दे आर अपॉइंटेड बाय, दे आर नॉमिनेटेड बाय द प्रेसिडेंट ऑफ यूएसए, एंड देन आफ्टर दैट they must be confirmed by the Senate. That means their Rajya Sabha. So that is public hearing is there. इसका प्रो क्या है? It is a transparent, accountable and democratic legitimacy. But cons क्या है? It is a politicized because president alone is deciding who can be the next Supreme Court judge over there. So ideological polarization is possible. Partition, confirmation. Okay. So India versus USA में देखो, India ये opaque nature, opaque है इसका, but insulated from partisanship. USA transparent है, but politically okay, politically this partisanship is there in USA model. That is very easy. This thing already I have covered in class also. If you have covered judiciary chapter already, okay, I think few of the batches I have already covered. So this is very easy, straightforward question, not to be understood that this question was very difficult. No, not at all. Now question number 14. Examine the evolving pattern of central state financial relations. Okay. In the context of planned development in India. Okay, planned development means before Niti Aayog there was a planning commission. At that time, first year planning, second year, second plan, third plan, this used to be there. How far have the recent reform impacted the fiscal federalism in India? So current affairs में अगर देखें क्यों है? Because 15th Finance Commission report था, GST regime आया, इसमें centralization of indirect tax हो गया, compensation dispute still is there, Niti Aayog replacing planning commissions, CAG and RBI reports regarding on rising state debt and dependence on the center, Supreme Court verdict on cooperative federalism in fiscal matters. So these are in the news itself. So how to answer here is, so when it comes to the answer, so first is intro. Fiscal federalism in India has evolved from centralized planning to a cooperative model. Planned development, safe central state transfer, all these. So evolving pattern क्या है? Early decades में क्या होता था? What earlier centralized planning था via planning commission because states dependent on the plan grants only. Finance commission था, statutory grant थे, periodic devolutions article 280. गडगिल फार्मूला था वहाँ पे। पोस्ट 1991 में बेसिकली नीति आयोग रिप्लेसेस प्लानिंग कमीशन। सो रिसेंट रिफॉर्म क्या हो गया, 14th फाइनेंस कमीशन इंक्रीज स्टेट शेयर ऑफ डिविजिबल पूल फ्रॉम 32% to 42%, नाउ इट इज 41% ड्यू टू जम्मू कश्मीर ऑर्गेनाइजेशन। देन वन नेशन वन टैक्स जीएसटी, अभी डायरेक्ट टैक्स में भी दे आर थिंकिंग द सेम वे ओनली। सेंट्रली स्पॉन्सर्ड स्कीम्स आर देयर, करंट लाइक डिले इन जीएसटी कंपनी, दीज थिंग्स you can answer, so that is not that difficult. Okay, if you know those basics then you can answer easily. Next question, I think this is the last question regarding the polity part. Okay, this is the last question regarding the polity part, then polity questions have been done. National Commission for Protection of Child Rights has to address the challenge faced by the children in the digital era. Digital era because आजकल आप बच्चे देखते हो, they used to keep watching that reels only. They are not basically having their food without watching the TV or reels. So that is the one important, children in digital era. That is the case. Or because of the OTT also. Examine the existing policies. Whatever the policies are there, we need to examine that and suggest measures the commissions can initiate to tackle the issue. That means you have to give your own suggestions also. That means you also have to work just like for example Administrative Reform Commission. You have to give some solutions. So reason क्या था current affair में, because NCPCR basically set up under Commission for Protection of Child Rights Act has been active on the issues like child pornography, online gaming addictions, unsafe edtech platforms, again unsafe edtech platform definitely, and cyberbullying. The 2023-24 reports of rising child exposure to harmful digital content, cyber scams and AI generated child sexual abuse materials. Supreme Court and Parliament debate also on regulations of OTT online gaming that has been closed down recently only. That is the reason UPSC asked this question. So यहाँ पे क्या existing policies, क्या existing policy like IT Act 200 है, POSCO Act है 2012, then Juvenile Justice Act is there, then National Cybercrime Reporting Portal is there, then Digital India Act draft is there, education and awareness scheme like PM E-Vidya, NCERT Digital Safety Guidelines. These are the existing policies whatever right now we are having. Again, if you are able to mention just 2 to 3, that is more than enough for your answer. Then measures that they can initiate, that means now we need to give some suggestions. Suggestions क्या दे सकते हैं, like formulate child specific digital safety guidelines. Collaborate with, for example, the Ministry of, that is, for example, Electronics and this Information Technology, NCERT, NGOs of for digital literacy campaign, strengthening monitoring of edtech and gaming platform that has already been done recently, helping and counseling for victims of cyberbullying, recommend amendments in IT and POSCO law for AI generated content and deepfake, conduct periodic audits of compliance by social media and OTT platform. That is the question. So I think this was the last question of the polity part. Now governance part also we can cover directly without any wasting time. Directly we come to the question. So question was this: women's social capital social capital complements in advancing empowerment and gender equity. Social capital means basically networking. So syllabus क्या है, welfare schemes for vulnerable sections and issues relating to the social justice and gender equity. So women reservation, self-help groups and global discussion G20, India's presidency 2023 stressed women's lead development. That is the reason this question was asked. So again, term social capital क्या होता है? Social capital means network, relationship, because आज के ज़माने में क्या है, जो network है, that is also one of the net worth you are having. So network, relationship, trust, reciprocity within groups that facilitate cooperation and collective actions. So women's social capital क्या होगा? Self-help groups, collectively they are there, Mahila Mandals, Kudumsri of Kerala governments, microfinance groups, online communities, informal solidarities like confidence, knowledge sharing, access, these things will be there. And how it advances empowerment and gender equity. See, enhances economic agency, example collective savings, microcredit lead to entrepreneurship, they will open some, this startup, increase political participations like Gram Panchayat elections, promote social empowerment, breaking taboos, challenging gender stereotype, acts as a support in crises like domestic violence, digital literacy, health awareness, that you can write. This is also an easy question, not as difficult. Next question is e-governance पे आया था. Again governance, well, so this is the second question on governance. E-governance projects have a built-in bias towards technology and back-end integration than user-centric design. That means जो e-governance है उसमें जो सबसे ज़्यादा maximum जो ध्यान गवर्नमेंट देती है, गवर्नमेंट गिव्स मैक्सिमम कंसंट्रेशन ऑन टेक्नोलॉजी, मैक्सिमम कंसंट्रेशन ऑन बैक एंड इंटीग्रेशन इंस्टेड ऑफ वेदर इट इज इन यूजर फ्रेंडली और नॉट, whether जो real beneficiary है they are able to use that technology or not. That was the question. Or such question already UPSC has asked earlier also. If you read PYQ, then such question was asked already. ओके, सो रीजन क्या था, क्यों? बिकॉज डिजिटल इंडिया एक्ट था, कोविन पोर्टल ग्लिचेस, जीएसटीएन टीथिंग इशू, डिजिटल डिवाइड रिपोर्ट्स ऑफ नीति आयोग, ऑल दीज थिंग्स वर देयर. सो पार्ट ए में आपको बताना है बाइस टुवर्ड्स टेक्नोलॉजी और बैक एंड इंटीग्रेशन. ई गवर्नेंस ऑफन प्रियोरिटाइज बिल्डिंग लार्ज आईटी प्लेटफॉर्म लाइक आधार, like GSTN, DigiLocker, and for example Digi Yatra, all these things. Focus on digitizing government process and database. Success measured in transaction online, not user satisfaction basically. So second part क्या? Neglect of user centric design. So citizen face barriers because low digital literacy, पुअर UI, पुअर जो भी उनका फॉर एग्जाम्पल जो इंटरफेस है दैट इज वेरी पुअर. लैंग्वेज गैप इज देयर, जो भी आपने दिया वो इंग्लिश में दे दिया है कंटेंट, बट लोकल लैंग्वेजेस में द कंटेंट इज नॉट अवेलेबल. केस ऑफ एक्सक्लूजन, आधार ऑथेंटिकेशन फेलियर्स, ब्लॉकिंग वेलफेयर, जीएसटी पोर्टल कॉम्प्लेक्सिटी फॉर स्मॉल ट्रेडर्स, कोविन वैक्सीन स्लॉट एक्सेस इश्यूज फॉर रूरल पीपल्स की दिक्कत हुआ था, वीक ग्रीवांस रिड्रेसल मैकेनिज्म्स. सो व्हाट कैन बी डन नाउ? पॉलिसीज जो भी बनाएंगे, डिजिटल इंडिया मिशन, नेशनल ई गवर्नेंस सक्सेस आप लिख सकते हो लाइक डीबीटी सेविंग्स, डायरेक्ट बेनिफिट ट्रांजिशन स्कीम्स, डिजी लॉकर अडॉप्शंस, लिमिटेशंस, वे फॉरवर्ड आप लिख सकते. बेट फॉरवर्ड में सबसे पहले क्या लें? मल्टीलिंगुअल पोर्टल शुड बी देयर, असिस्टेड सर्विस सेंटर शुड बी देयर, इंक्लूसिव डिजाइन, सिटीजंस फीडबैक लूप्स दैट नीड टू बी देयर. थर्ड क्वेश्चन ऑन जो पूछा गया था इन द गवर्नेंस जो के सेक्शन, दैट वाज दिस: civil society organizations are often perceived as being anti-state actors than non-state actors. Do you agree? That means whether you consider civil society organizations as anti-state or anti-state or non-state. That was the question. Again 150 words only. So यहाँ पे क्या करना है? Because debate was already there on foreign fundings like FCRA restrictions, civil society organizations role in climate protest, farmers movement, rights advocacy, all these things. So आपको क्या करना है? First is perceptions क्या है? So first perception is regarding civil society organizations as anti-state. So because why they are anti-states? Because many of the or some of the civil society organizations, they basically criticize government policies like environmental clearance, human rights, displacement. They mobilize protest. Example anti-CA जो for example Citizens Amendment Act था, protest, farmers movement. International NGOs sometimes accused of influence domestic politics. Like recently, for example, this was one ODM करके one organization that was actually also criticized for that. Reality क्या है? CSOs as a non-state actor because they provide last mile delivery of welfare like education, health, disaster. Supplement government efforts in for example sustainable development goals, environment, women empowerment, digital literacy, and they act as a watchdog also, ensuring the transparency, accountability, participatory democracy. So must mention some facts like Article 1921 you can mention, FCRA amendments you can mention, Niti Aayog NGO Darpan portal you can mention, example like Seva, Pratham, Mazdoor Kisan Shakti Sangathan. These things you have to mention as an example over here. So this is for example again next question, fourth question I suppose. What are environmental pressure group? Again direct question hai, what are environmental pressure group? It is not that difficult that you should not answer, you have to answer no matter how what. Discuss their role in raising awareness, influencing policies and advocating for environmental protection in India. Ekdam simple halwa question hai. Because why it was asked? Because COP 28 December 2003 Dubai debates on climate justice, India's stance on net zero, environmental group actively lobbied, protests in India over EI notification 20, these was, and Supreme Court judgments on forest rights, air pollution control, eco sensitive zones like petrol vehicles, E20, all these things are going on. So here you can write directly, what are environmental pressure groups? They are the organized group that seek to influence government decisions basically in matters of ecological protections. Can be formal NGOs like Center for Science and Environment, Greenpeace India, or grassroots movements like Chipko, Narmada Bachao Andolan. Ekdam halwa. Their role क्या है? Their role है raising awareness, influencing government policies, advocacy through legal means, global networkings, these things. Now next is inequality in India. This is next question. Inequality in India in the ownership pattern of resource is one of the major cause of poverty. Discuss in the context of paradox of poverty. What is paradox of poverty? Paradox of poverty ये है कि इंडिया में resource की कमी नहीं, there is no lack of resources in India. Resources are there, but still people are poor. Like for example, India में food grains are there, but still people are hungry. Like there is, for example, when it comes to the milk, when it comes to the food grains, India is number 1 or number 2. But when it comes to hunger index, we are 111 rank out of 124, 125. That is paradox of poverty. Why, for example, okay, few individuals are having okay large okay resources, but many individuals like 50% of the individuals having very less resources. That is paradox of poverty. वहीं पे हम लोग like fourth largest okay economy है, but per capita income basis पे we are not even in top 10 even, not top 10, top 30 also. So why this question was because of global wealth report, नीति आयोग report, paradox of poverty discussed like this. So यहाँ पे आपको क्या लिखना है? Define paradox of poverty, that means coexistence of resource abundance and persistent deprivations due to unequal inequality in ownership pattern of resource like land concentration, rich landlord versus landless laborers, urban asset concentrations, real estate. For example, earlier to purchase home it required 10 to 15 years, 10 to 12 years of total income you can purchase home, but today it requires around 30 to 40 years of total income that required to purchase a home in metro cities or in tier 2 cities. That means urban asset concentration, there is a for example inequality, unequal access to education, credit, healthcare, all these. So paradox of poverty क्या हुआ कि despite economic growth, despite rising GDP, large section still remain poor. That is paradox. India, high GDP growth, that is jobless growth, booming billionaires, okay, entrepreneurship, startup culture, but still hunger and malnutrition still persist. Example, agriculture surplus alongside farmer poverty, IT boom alongside informal job precarity. That is the problem. So what policy need to be? Land reform, MG Narega, national food security, sustainable development goal number 1 and 10, that is end poverty, reduce inequality, and Oxfam inequality report also that you can mention. So next question is about 17 question, that is in contemporary development model, that means today's development model, decision making and problem solving responsibilities that are not located close to the source of information and execution defeating the objective of the development. Simple कि we require development at the local level, but where decisions are made at the central government level, at the state level, but not at the local level. That is the main problem is. So that is what the question was asking basically. So here you can write example, core idea क्या है कि many development programs they are designed and controlled at the union and state level but executed locally. This misalignment weakens the outcome. So part A में आप लिखो problem क्या है कि schemes often designed in Delhi or state headquarters, little local context has been given. Example like centrally sponsored scheme, one tailored schemes that has been given uniformly, result mismatch between policy and ground realities like leakage होगा, poor adoptions will be there. So why decisions should be closer to information execution like Panchayati Raj inverses subsidiarity. Principle of subsidiarity क्या होता है? Principle of subsidiarity means decisions should be made at that level where it is okay need to be there, not at every level there. Okay, local institutions best known community needs water, sanitation and health. Case like Kerala's participatory planning, people's plan campaign. Critical evaluations आप लिख सकते हो कि centralization also has merits. यूनिफॉर्म स्टैंडर्ड होगा, इकोनॉमी ऑफ स्केल होगा, नेशनल इंटीग्रेशन होगा लाइक जीएसटी, बट विदाउट लोकल ऑटोनॉमी, विदाउट अकाउंटेबिलिटी, विदाउट फ्लेक्सिबिलिटी, डेवलपमेंट लॉसेस इफिशिएंसी एंड इंक्लूसिविटी. नाउ इंटरनेशनल रिलेशंस पे दिस वाज द क्वेश्चन. तो अभी तक वट एवर द क्वेश्चन वी हैव कवर्ड they were either social justice or for example in governance. Now comes to the in IR में two questions they have asked. First question is this: India Africa digital partnership is achieving mutual respect, co-development and long term institutional or partnership. आपने UPI के बारे में बताया होगा कि most of the countries they are also asking about UPI. That was the thing. Like India Africa summit हुआ था, then digital India stack export हुआ, G20 दिल्ली declarations हुआ. So यहाँ पे आपको that things you have to mention. This is very easy exam. Now next question is this, I think three questions were from the IR. With waning of globalization, that means globalization is going okay back now. Post Cold War world is becoming a site of sovereign nationalism, मतलब protectionism basically. So this is about the that part. So यहाँ पे आप waning of globalization में क्या ले सकते हो? Like slowing of trade liberalization. You have seen like Trump हर country में जाके उद्यम कर रहा है वो. Slowing of trade liberalizations. Supply chain reshoring and nearshoring. सब लोग चाहते हैं supply chain हमारी country में हो, which will not be other countries like. Decline of multilateralism like WTO crisis, weak United Nations. Rise of sovereign nationalism. What is this? He state they are prioritizing security, self-reliance, protections of domestic industries. Examples like US and EU subsidy raise, China's tech self-reliance, India's Atmanirbhar Bharat, vaccine nationalism during COVID, food energy nationalism like wheat export ban, oil cartelizations, all these things are. India का इसमें क्या relevance रहेगा? India balances globalization because G20 presidencies, free trade talks with nationalism like Atmanirbhar, digital sovereignty and supply chain resilience. Next question is, energy security constitute the dominant kingpin of India's foreign policy and is linked with India's overarching influence in Middle East countries. Okay, so overarching influence in Middle Eastern countries के बारे में. How would you integrate energy security with India's foreign policy trajectory in the coming years? So ये क्यों पूछा है? Because India imports 22% of crudes from Russia, drawing US tariffs up to an acquisition of profiteers. Then, for example, Middle East centrality, India still stores 60% of the crude from the Gulf only, and in corridors like IMACA. So that is the reason energy security is a kingpin, because India imports 87% of crude. Middle East dominant supply. Gulf hydrocarbons plus diaspora plus remittances is equal to strategic influence. We can put correct. So integrating with foreign policy like diversifying source like Russia, US, Africa, हर जगह से ले लो. Deepen Middle East okay ties, okay, and balance US pressure also in green transition. That is key fact you can mention. The last question that was asked, that is also IR only. The reform process in the United Nations remains unresolved because of that delicate imbalance of East and West and entanglement of the USA versus Russia China alliance. Examine and critically evaluate the East-West policy confronting in this regard. So this question was asked here. So current context here, Ukraine war 2022, Russia repeatedly vetoed UNSC resolution against it. Gaza conflict, USA vetoed ceasefire drafts. Then for example again, okay, Liechtenstein for example veto initiative, summit of future, French-Mexican proposals for voluntarily veto restraint in mass atrocities, all these things. So that is the question was asked. So reform remains unresolved because UNNC expansion, G4 versus uniting for consensus versus African Union, all these things we can mention. East-West policy confrontations, Russia-China alliance, USA with allies, all these critical evaluations like positives, negatives, realistic, that you can write. So that was the total, I think 4 questions were asked from the GS paper 2 itself, also in this IR part itself. So I think if you okay check questions like in IR, so in IR if you ask me, then there are one question that is difficult little bit, because if you have not read properly the current affair, basically India African Digital Partnership, that was one difficult. Rest of the 3 they were not difficult. In polity hardly any question was difficult, and in governance also hardly any question was difficult. So for my opinion, this GS paper 2 was on the easier side, but it depends basically how you are going to write over there. So whatever the content here I have presented to you, if you are able to mention just 60 to 70% of the content in your mains answer sheet, then I think you have done your job wonderful. You will get around 90-100 marks easily. Okay, so that's it for today. Thank you, and we'll see you in the next class.